My name is Attorney Wendy Guthro. I am an elder law, estate planning, and probate attorney with my physical office located in Burlington, Massachusetts. And I'm licensed to practice law in the Commonwealth of Massachusetts and the state of New Hampshire. There are some people joining us from other states this evening. And just to inform you that I am not authorized to give you legal advice for anyone that is not residing in Massachusetts or New Hampshire. But you can take a lot of the information that I'm going to share with you tonight, which is about legal documents you should have in place in the event of a potential memory loss, or if you're already incurring some memory loss. And whatever I tell you this evening really is applicable in whatever state you live in, so that you should seek a qualified elder law attorney or another practitioner in your state to obtain the information that we are going to discuss tonight. So why don't I start by bringing up our PowerPoint. So tonight we're going to talk about protecting loved ones, essential legal documents to have in place in the event you are sustaining memory loss. My next screen I had up already, and it's a little bit about me. As I said, Wendy Guthro, Massachusetts and New Hampshire licensed. I'm a member of the National Academy of Elder Law Attorneys, which is a great organization that keeps us up to date on all current law changes in the practice of elder law. Our objective tonight in this webinar is to understand the need for being prepared in the event of a memory loss, the role and importance of a durable power of attorney, or a durable power of attorney for finances, as it's called in New Hampshire, as well as the significance of having a healthcare proxy and other healthcare documents in place. There's other essential legal documents that I'll review with you. And then at the end, we're going to take some questions and answers. I've put a couple questions up that are common questions, but I will be taking questions, your questions at the end. You can either type them into the chat, or if you wish that you'll have the flexibility of unmuting yourself, and we'll be able to ask any questions at the end. This is a recorded webinar that you all had to hopefully sign off on when we started. So memory loss is not just for an Alzheimer's or a dementia diagnosis, but memory loss, also referred to as cognitive impairment, happens in multiple types of diseases that we can be afflicted with. Many people are associated with Alzheimer's or dementia, but you also have cognitive impairment or memory loss sometimes with an ALS or a Parkinson's diagnosis, or a traumatic brain injury from an accident, or a birth defect, or just regular cognitive impairment that sometimes happens with the regular aging process. So we've all been in the situation that we walk into a room and we're like, what are we here for? So it's very common. Now, that is really very traditional, age-appropriate memory loss. Most of us can easily recoup. We walk back into the room we were in, figure out what we were doing, and then we go back into the room and we remember what we were there for. But the things we're talking about this evening are a lot more involved than that. It's that when you can't really self-cure a momentary memory loss. So as I said, it's part of the aging process. So it's not something that we have to really be that alarmed with as we're aging. So if we can really view it as that this is part of the regular aging process, but the things that we're going to talk about tonight are when memory loss is a result of a serious illness, such as some of the ones listed on this screen. Legal and medical experts encourage people recently diagnosed with a serious illness, particularly one that is expected to cause declining mental and physical health, to examine and update their financial and healthcare arrangements as soon as possible. That came from the National Institute for Health. So in that vein, I am doing this webinar to see if we can get everybody where they need to be for what might be coming down the pike. So, understanding the importance of legal preparedness. Basic legal and financial documents, such as a durable power of attorney, a healthcare document, all healthcare documents, a will, and a living trust, are available to ensure that a person's healthcare and financial decisions are carried out. So I'm going to go into detail on these documents listed above at this webinar. The first document that we're going to speak about is going to be your durable power of attorney for finances. The next batch of documents are going to be your healthcare documents. That will consist of your healthcare proxy, also referred to as your durable power of attorney for healthcare in New Hampshire. Additional healthcare documents are an advance directive, also referred to as a living will, your HIPAA. Another document is called a MOLST or a POLST, and then a do not resuscitate order. After we transition from the healthcare documents, we're going to move into the need for a will and or a revocable living trust. So we're going to take a deep dive right now into our durable power of attorney for finances, also called a power of attorney for finances in New Hampshire. And I think in New York, it's also referred to as that. It allows a person to appoint someone who you trust emphatically to manage your finances for you. And it can be used during your capacity and incapacity, depending upon how that document is drafted. That person who you are empowering with the ability to help you with your finances is referred to as your attorney in fact in Massachusetts, or your healthcare agent or proxy in New Hampshire and other states. What is the benefit of naming someone to handle your finances in the event that you are not able to do it yourself, or for mere convenience, you would like someone to be able to do this function for you? Having a durable power of attorney in place removes the need to go to court to appoint someone to be your conservator to handle your financial matters if you do not have a durable power of attorney in place in advance. A durable power of attorney is normally needed, or a or a conservatorship is required if someone needs to put you into an assisted living where you cannot speak for yourself, or required in most skilled nursing facilities or nursing homes in Massachusetts. So we do want to have a durable power of attorney in place for someone to handle your finances if you are not able to, or merely for convenience. This is what a durable power of attorney looks like. This is the front page of one, and our client here is Bug Lee. So I, Bug Lee, and we normally reference the last four numbers of your Social Security number, are creating a power of attorney, and we're going to comply with Massachusetts law. And then you state that I appoint here, Bug Lee appointed Happy Lee to serve as their attorney in fact. And then we can appoint a successor attorney in fact if the first person that you have appointed is either not capable of serving or is not available to serve. This particular power of attorney that I draft here in my office is approximately 15 to 25 pages long, and it is designed for your agent or your attorney in fact to handle everything that you would need done if you yourself were standing in front of a bank teller, speaking to your retirement fund, and you want to maybe change the bank account that you're going to get your money deposited into, your financial advisor to make a move or retitle an account. Some powers of attorney even allow someone to change a beneficiary designation on an asset if you wish your power of attorney to do that. So there are a number of powers within a power of attorney: to sell real estate, to sign legal documents for you. So it's important for you to review what powers you are giving to your agent. When I am doing the drafting of a power of attorney, I ask my clients to only appoint people that you trust emphatically, because you do not really want to tie the hands of the person that you are empowering to do things for you, because you will not be able to speak and represent yourself in most cases. So you want to be able to give them very broad powers. So you do not really want to limit powers in this particular case. The next set of documents we're going to speak about are healthcare documents. Under this heading of healthcare documents, we'll talk about your healthcare proxy, your advanced directive living will, what a HIPAA form will do for you if you have memory loss, what a MOLST or POLST, which is a medical order of life-sustaining treatment, or a physician's order of life-sustaining treatment, and then a do not resuscitate order. So, understanding a healthcare proxy. A healthcare proxy, also called a durable power of attorney for healthcare, gives a designated person, your healthcare proxy or agent, the authority to make healthcare decisions on your behalf, only when you lack the capacity to make your own decisions. Now, this is very different from the durable power of attorney for finances, right? Because you could have that document be there for you whether you have capacity or not. But a healthcare proxy is only invoked by a healthcare professional when you lack capacity to make healthcare decisions for yourself. This is a sample of a healthcare proxy. And here you can see we have Bugley again, and he has appointed his lovely wife, Happy Lee, to be his healthcare proxy. But if Happy is not available, then he has appointed his child, Lovely, to be a successor healthcare agent. Under a healthcare proxy, it is somewhat unusual to appoint two people to serve in that capacity at one time. And that is because the medical community does not want to have to deal with two different people making medical decisions. So we are going to only appoint one person to make medical decisions for you in the event you are not able to communicate your own healthcare wishes to the medical community. So if you are suffering from memory loss or you are incapacitated in any way, we want to have a healthcare proxy in place. And if we don't have a medical healthcare proxy in place, we might have to go to court and ask for a guardianship by the judge to be ordered for someone to step in and make medical decisions for you. So by having, again, the healthcare proxy in place for someone to make medical decisions for you, it removes the need of having to go to court in an 11th hour situation to get a guardianship over you for someone to make medical decisions over your body. And the durable power of attorney for finances prevents someone to having to go to court to get a judge to order conservatorship over you for someone to handle your finances. Still under the healthcare documents, after the healthcare proxy, I would like you to have an advance directive in place. And an advance directive is a document that memorializes whether you wish to be kept alive on life support if death is imminent. You state yourself in writing whether you would like to be kept alive on life support or not, maybe how long you would like to be kept alive on life support. Do you want the administration of artificial nutrition? Do you want just comfort care to be so that you are in place, so that you are just pain-free? But what I would like to remind you is that on an advance directive, it is also called a living will in some states, that this document is not called into play until you are really in an end of life situation. So that's very different from the previous document we spoke about, which is a healthcare proxy, which that is really in place while you are alive, and we are trying to take measures in most cases to get you back to full health. So healthcare proxy is really all the way along whenever you're incapacitated in any way, whether from a memory issue or a physical disability or a cognition issue. And also that is a document that is only activated when it's needed. And so a healthcare document, once you gain full capacity, you are then back in charge and your healthcare proxy is withdrawn from use. But on an advance directive, we are normally at end of life, and that if you cannot speak for yourself, it's a document that is presented to the medical community, and it states that you do or do not want to be kept alive on life support. And this document, I have seen that when you memorialize these very difficult decisions, especially in a child situation, when you are a parent and maybe you have a spouse and they're not alive or they're not available, and a child has to step in and make this very difficult decision, it's really wonderful that you have memorialized your wishes. So the burden of making these very difficult decisions isn't on a child's shoulders or a friend's shoulder, if that's this person that's got to make those decisions for you in that difficult situation. The next document we're going to speak about is a HIPAA. This is a federal document. It is throughout the United States. And in a HIPAA document, it names those people you would like to have access to your protected medical information, and to be able to have those same people obtain that medical information about your medical status from any medical institution where you have a HIPAA form on file. Now, I said a HIPAA is a federal form. They're abundant in almost any hospital or medical situation you'll find yourself in. The institution will pull out their own HIPAA form or their own advance directive or their own healthcare proxy form and ask you to fill it out. Now, when you do that, that form is on file with that particular medical institution. It is not to be used at other medical institutions. So to have a HIPAA advance directive, a healthcare proxy that is created and drafted to meet the needs and to communicate your medical wishes at any and all medical institutions. So what you're going to want to do once you have a HIPAA and an advance directive and a healthcare proxy in place is you're going to take those documents and put them on file with your primary care physician. And if you have a hospital of choice, that you should have those on file and in place in the event of an emergency. Some clients also give a copy of these documents to, especially the advance directive and the healthcare proxy, to their healthcare agent or someone that is going to be in charge of making these medical decisions for them. So a HIPAA is different than most of the other documents we've spoken of so far, because on a HIPAA form, you are not naming one person. If you would like more than one person to have access to knowing what your medical status is and to have access to your protected healthcare information, you can name a group of people. And even on the document, you can simply say, all of my children and their spouses, all of my grandchildren over the age of 18. If you want to name specific individuals, such as I see some clients name a best friend or maybe one of their siblings and not all of them, you can name individual people or you can name a group of people. And this has a standing order until you have revoked it. So if you don't want someone that you have previously named to have access to your healthcare information, you would need to go to the institution that you put it on file. You need to revoke it and put a new one in place. So on the advance directive and the HIPAA, these are not used as frequently, but on the HIPAA form, I think it's very important for if you want people to be able to call into the hospital and to know that you are there, first of all, and to get a status update on you, these people would need to be listed individually or in a group under your HIPAA form. I'm sure most of you are aware that it's getting more difficult when we're going into medical institutions about disclosing any kind of medical information. You'll even see in new hospital construction that they're not allowing multiple rooms for patients, that you're only allowed to have one patient per room so that it complies with a lot of HIPAA regulations. So as we're getting more sensitive to medical information not being disclosed to people inappropriately, you're going to want to have a HIPAA in place so that the people you do want your information shared with, it will be shared with in the time when it is needed. The next document in the medical, in the healthcare documents is a MOLST or a POLST. Medical orders of life-sustaining treatment, or replace medical with physicians. Massachusetts allows medical professionals, not just physicians, to complete these forms. As you can see in pink at the top, this document and the next document can only be completed by medical professionals. In this case, it could be a nurse practitioner, it could be a nurse, it could be a doctor, it could be a physician's assistant. So anyone in the medical community can do this document with you. So a MOLST is based on an individual's right to accept or refuse medical treatment, including treatments that might extend your life. So it's a hot pink sheet of paper in Massachusetts. And it's hot pink because oftentimes when clients complete this form with the help of a medical professional, they put this on their refrigerator because many EMTs are trained to go and look for this document attached to someone's refrigerator because it has, as you can see in number A, it has a cardiac pulmonary resuscitation, right? Do we want to be resuscitated? So when you're in a medical situation like that and you have this completed with a medical professional, they might stop from applying a resuscitation situation or resuscitation work in this medical situation. So it goes into details on whether you want to be resuscitated. Do you want to be put on a ventilator? Would you like to be transferred to a hospital, or do you just really want to die at home? So these are things that are newer in the last 10 years and that they're growing in popularity, and that I encourage all of my clients to have these in place, and that you either can fill out this side of the form, or there's a part B to the form, a second page, that allows you to kind of state under what conditions would you maybe like a ventilation supplied? What situation would you maybe like dialysis applied? So do speak to your medical professional about having a MOLST or a POLST form completed to complement the other documents that we've already spoken of. This next document is issued also by a medical professional, and this is a do not resuscitate order. It instructs medical or healthcare professionals not to perform CPR in case of a stopped heart or stopped breathing. Now, I have known some clients very young with not very many medical conditions that have this order in place. And when I've discussed it with them, I said, you're very young, like, why would you have this in place? And they say because they don't want any extraordinary measures to be taken to extend their life. I also have other clients that have many medical situations and that they've had previous heart issues. And even with that, they do not want a DNR in place because they still want every effort to be made to prolong their life. So again, this has to be filled out with a medical professional, and it is a conversation that is taken very seriously by the medical profession, and that they do want to make sure, one, that you are competent and of sane mind when you are making these very serious decisions of whether you want any resuscitation if your heart has stopped or you have stopped breathing. So that is the last of the healthcare documents. And now we're going to go into a will and a trust and how these documents would be helpful for you to have in place for memory loss or for any medical situation where you are going to have declining health. So a will and a trust often can accomplish the same thing. So a will is a legal document that distributes your assets after you pass to the next owner. And we're going to use the probate court to do that. Versus a trust is a legal entity that you hold your assets during your lifetime, and the trust distributes them after your passing without using the probate court system. A graphic to explain the difference is that a will on one side of the screen goes to the probate court and it distributes your assets to whomever you have named in your will. Versus a trust you create and you appoint a trustee, and that trustee, upon your incapacity or passing, is in charge of distributing your assets to the named beneficiaries that you wrote in your trust. Now, the benefit of having either one of these documents in place, if you are starting to experience memory loss, or if you are just fine, but you are fearing that this is something that might happen, or if you're in the best of health and you want to start thinking about how you would like your assets to transfer upon you passing away, or if it's a husband and wife, maybe about on the first of you to pass, you'd like all of your assets to go to your surviving spouse. But then on the passing of the surviving spouse, how you would like the assets to pass to your children or your heirs at law or to friends and relatives. Now, that passing of the assets, you need to put a little time and thought into that. But more importantly, it's important that you exercise either one of these options while you have capacity to do so, because both of these documents require a high level of capacity and competency in order to activate and to sign these documents. Along with these two documents, the first document we spoke about is a durable power of attorney. That also requires a very high level of competency for you to be able to sign and activate these documents. Many people have a will and they don't have a trust. And so they ask me, if I have a will, do I need a trust? Well, a will, you use the probate process and courts, and it's expensive and it takes at least 1 to 2 years in order to get your assets distributed to your heirs at law, where a trust is much less time and much easier and normally less expensive. So a trust is simply a legal entity that can hold your assets during your lifetime and distribute them after your passing without using the probate court system. So if you can think about a trust as simply a container to hold things, you can wrap your head around the concept of what it is and how you might be able to use it. This is an example of a trust. A trust, again, is a container, and you are the grantor, meaning that you're putting your assets into this trust. You're the trustee, and that means that you have to follow all of the directions that are written on your trust. And you are also the beneficiary of the trust during your lifetime. And then what we're going to do is we are going to name successor trustees and successor beneficiaries. So while you're alive and you have capacity, we are going to transfer usually the deed to your home into your trust, your personal property into your trust, and you are going to transfer all of your financial assets, bank accounts, CDs, not retirement assets. We're going to maybe name your trust as the beneficiary of your retirement assets, but we're not going to transfer your retirement assets into this trust. But as you can see, your mutual funds, your stock portfolios, all financial assets that are not retirement, another word for that is non-qualified. So we're going to transfer all those assets into your trust while you have your memory, while you have capacity, and you are going to name who you would like to receive these assets upon your passing or incapacity. And that action of putting those assets into your trust is called funding your trust. So to just give a quick overview of the essential legal documents, we went over the durable power of attorney for finances, your healthcare documents, which were your healthcare proxy, advanced directive, your HIPAA form, your MOLST or POLST, your do not resuscitate order from a doctor. Those were your healthcare documents, and then a will and or a living trust. So as I said at the beginning, you can put some questions in the chat. I'm going to take it off of a share screen in a moment, and we are going to then go over some questions and answers. Here are a couple questions. Everyone can unmute themselves if they'd like, and we'll get ready to just start to answer some questions. But one question is, should I put my durable power of attorney for finances on file now with my bank, investment advisor, and retirement assets? And the answer is yes. If you have a trust in place, you often don't need to put the durable power of attorney on file because a trust is more powerful than a durable power of attorney. Should I put my healthcare documents on file now with my doctor and hospital? Yes, you should. You should do it while you're have all of your capacity, while you're not having your memory challenged, so that your physicians know that you made these decisions while you had full capacity. A couple more questions people ask me is, do I still need a will if I have a revocable living trust? Yes, you do, because if you fund your trust right now with your home, your personal property, all your non-retirement assets, and say you inherited an asset from someone passed away and that you didn't have time to transfer that asset into your trust bank account, well, then we will use your will, often referred to as a pour-over will, to pour that asset through the probate process into your revocable living trust, and it will then be distributed upon your passing, however you have indicated you would like in your trust. Should I transfer my assets into my revocable living trust now? Yes. I want all of my clients to fund their revocable living trust during their lifetime. Because if you don't, I will need to open up probate on your assets. And that the goal of having a revocable living trust is to avoid probate. So if you don't transfer all of your assets during your lifetime or name a beneficiary, either your trust or someone else, as the beneficiary of that asset, we will be going to probate to determine who the new owner of that asset is. And we can then pour it into your trust and look at your trust to see who you selected is going to be the next owner of that asset. There is one exception to that, and that is if you have an asset that is jointly titled with another person, such as a jointly held bank account between a parent and a child. That will avoid probate, but it does open up other issues of how is that asset held with that other person going to be equally divided according to your wishes in your will or your trust? It won't be, because a jointly titled asset is usually considered the property of the other joint tenant, the joint owner. So if you pass away and you're the parent, you have 5 children, you named one of your children on that bank account with you, that bank account is now the property of that one child. And the other children normally cannot force that one child to equally distribute that bank account to all of them equally. So I'll come back to this in a moment, but I'm going to open it up to take some questions. I see a couple things in the chat, so I'm going to stop the share and then we'll go back to the share. And let me just change my view here so I can see everybody. And as I said, if you'd like to ask a question, you can unmute and let me read our questions. Can you clarify the difference between a MOLST and a DNR? Yes. A MOLST is a document that covers everything from being resuscitated for a heart attack or your heart stopping, or you stop breathing, where a MOLST also includes whether you want to be on dialysis, do you want to be on a ventilator, and a number of other things, where a do not resuscitate order only refers to resuscitation of your heart, if your heart stops or if you stop breathing. So they will take all measures to resuscitate you if you do not have a DNR on file. But a MOLST is much more advanced because it doesn't just cover the heart issues, it covers other issues, and it also can name specifically what actions you want taken. You could say, if you check off, no, do not resuscitate me, do not put me on a ventilator, that's one side of the form. But on the other side of the form, you could say, do not put me on dialysis if there is no chance of me coming off. Put me on a ventilator only for 5 days. And if I cannot come off of a ventilator in 5 days, then pull me off the ventilator. So you have a little bit more wiggle room on the MOLST to be more specific with your medical professionals of what type of intervention you would like. As Joy asking, what is the difference of specifying POD, which is payable on death, on a bank account versus putting assets into a trust? So payable on death, it's also called a transfer on death, the TOD. It's also sometimes titled on a bank account as in trust for. It's also referred to as a Totten trust. So all of those designations are normally reserved for financial assets, most often a bank account, where you are the only owner of the bank account, or you might have it jointly titled with someone else. And in addition to that, you have a payable on death designation. That means, if in my example, I'll give you, you are the only one listed on the bank account. That means that you are the only one during your lifetime to be able to transact any business on that account. But a payable on death designation says upon your death, you would like it to transfer to whomever you have named. You'd normally need to provide their social security number when you are doing that at the bank. Versus, so you have that in place as a bank account with a payable on death designation. So you pass away, your person that you have named now is going to be the next owner of that when they bring your death certificate to the bank. Let's take it one step further, that the person you have named on that bank account has passed away before you and you didn't get to the bank to change that payable on death designation. That asset that you had listed as a payable on death designation to avoid probate will now not avoid probate, because that secondary person you've named is going to is not alive to get it, and you haven't named anyone else. So now you've taken an asset that you had hoped to avoid probate. It now has to go into the probate system to determine who gets it next. Versus if you took that same bank account, transferred it into the name of your trust, and you could in the trust specifically say, this bank account ending in account number such and such, I would like to go to my daughter named such and such. Or I want all bank accounts that are held in my trust to be equally divided to my 3 children. And I wanted to distribute 1/3 at the age of 25, 1/3 at the age of 35, and the last 1/3 distributed at the age of 40. But if any of those named beneficiaries happen to be in a nursing home or on public benefits or have developed a disability and are a special needs child, I have a standby trust in my trust that will transfer those assets that I was going to give to them outright into the special needs trust so that they are on public benefits. It will not disturb their public benefits. Or if we're trying to qualify them to go into a nursing home and we're doing a spend down, we're not going to let any assets go to that individual to possibly disturb their public benefits or mess us up when we're trying to do a spend down of someone's assets to get them into a nursing home on public benefits, which under current law is that they cannot possess assets over $2,000, with some other exceptions. So Joy, let me know if there's a follow-up to that. Elizabeth, do you need a DNR if you have a MOLST? I cannot specifically answer that question because my experience in the past is if you want a DNR, you should talk to your doctor and have it plastered all over your record as well as on your refrigerator for anyone that's coming in an EMT to administer life-supporting activities, medical interventions. But where the MOLST, as you can see on that example I gave you, is the first document. It's the first, do you want to be resuscitated from a cardiac perspective? I would think, Elizabeth, that you shouldn't need both documents. But because the MOLST is newer and not all hospitals, even in the United States, are even using the MOLST or the POLST yet, if you don't want to be, I would make sure your hospital of choice knows that you have a MOLST and that you want to make sure that a DNR will be honored. And it brings up another point I would like to speak about. Recently, I've been having clients that are in these 11th hour medical situations, and we are using the medical documents. One, who they can speak to, the healthcare proxy, right? Or the HIPAA, and that we're trying to get the medical community to listen to what we're saying about our loved ones, especially in end-of-life care, that, listen, we have a MOLST in place, or we have a DNR, that they weren't supposed to be resuscitated and you resuscitated them, that you need an advocate. You need an advocate with 2 legs and 1 big mouth that is ready to really communicate what your intentions are, and then provide them with the medical document, the legal documents to back this up, because you will find that in the medical community, they are geared towards saving lives. It's their knee-jerk response. So that if you don't want that, you really should try to make sure that you have communicated that to all your medical professionals. Let's see. Joy has a Follow-up. If bank accounts in trust are earning interest and dividends, is there a separate tax return that needs to be filed every year? So that's above my pay grade, but I'll answer it as best as possible because that is a question for a tax professional or a CPA. And it really depends the type of trust that you have. If a trust is a revocable living trust, which was one of the documents I suggested that anyone with upcoming memory loss, current slight memory loss, or anyone who has full capacity that wants to do good planning, that revocable living trust often uses your own Social Security number. So if you have your tax professional who is completing a tax return for your trust, any income or interest earned on that trust is normally reported on a K-1 report by your tax professional, and you fill that out, or you complete that, you attach that to your tax return, and it is treated as ordinary income or dividend income for yourself. But like I said, above my pay grade, I'm really not qualified to give that advice. So please do speak to a tax professional. Anyone that has attended any of my previous webinars, you know that I believe in the three-legged stool approach to living a good, complete life and carefree. And that is to have an attorney, a CPA or financial CPA or tax professional, and a financial advisor on your team. Because all of the things, these are all three intertwined genres of things that affect you. So that you do want to know that if you have a question, you want to have these people in your pocket to be able to call on them and say, oh, I spoke to my attorney and, she said that I could use my own Social Security number to claim my interest and dividends I earn on any assets that are in my revocable living trust. Is that true? Yes, it is. You want to get that response from your CPA tax professional. Joy continued with, we did that similarly, if a deed is moved into a trust, does that mean that the individual property tax deductions go away? That's an excellent question, because you use the word trust in general terms, and there are thousands of different types of trust. So the answer to that is dependent upon the trust you have. This seminar or webinar, we're talking about a revocable living trust where you are the grantor, you are the trustee, you are the beneficiary. Whenever you hold all those three positions in a trust, you are, it's as if you are still holding that asset individually, so that if you are able to get a property tax deduction, say maybe an elderly deduction or a veteran's deduction, or in New York, say, I know there's a star exemption from when my parents had their trust, that you should be able to get the normal personal tax exemptions on a piece of, on a deed, a piece of property, real estate held in a revocable living trust, for that particular trust. Conversely, if you have an irrevocable trust or an irrevocable trust, same thing, that cannot be changed or altered, that you no longer have any control over. Often my clients come to me and ask me to do an irrevocable trust for Medicaid planning, that we're trying to get assets out of our name 5 years in advance of potentially needing a nursing home. So I'm going to then divest myself of the asset, the house, the bank account, whatever it is, transfer it into the irrevocable trust. And in that situation, Joy, we do not have the availability to use those personal exemptions because we no longer hold those three positions. We might be the grantor. We are not the trustee in most cases. And we are a bifurcated position holder on the beneficiary status. I can get the income generated oftentimes out of an irrevocable Medicaid asset protection trust, but I can't get the principal. An example of that would be if I wanted to start protecting a $200,000 investment account I have, I'm going to give it to the trust. I can get maybe the $200 of income earned off of that in the investment portfolio every year. So that gets pulled off to me, but I can never get at that $200,000 in that irrevocable trust bank account that holds that asset. So the deed is moved into the trust. Does it mean that the individual property tax deduction goes away? Not if it's in an irrevocable trust most times, but it is dependent upon your town that issues or state that issues those tax deductions. Agree with the three-legged stool approach of professionals. Now, how to get the 20-something young adults just starting out to be able to afford that? Well, I think that the internet is a great source. I think that there is a lot of nonprofit organizations that are willing to step up and help. One of the people here on this webinar is part of a money management team at the Minuteman Senior Services organization, that if you need help managing finances and you qualify financially for that, that you can go to these organizations for seniors and sometimes disabled individuals and use some of those services. So I think that those services are also available in other target market groups for even these youngins, Joy. But I think if you can at least start them with a basic estate planning documents, and I mean, this is 2023 when I'm doing this webinar, and currently to get those, a durable power of attorney, your 3 healthcare documents, and a will in place, it's less than $1,000 for an individual. So that oftentimes I have parents that once a child reaches the age of 18 and that the parent loses a lot of ability to govern some of the things a child does, that they will pay for a child to have these documents in place. And they ask the child, could the parent be named as their power of attorney for finances or for health care, be on their HIPAA form. So it's really it's a good question that brings up other areas that you're right. How to get a 20-year-old who is, invincible and nothing's ever happening. They're living forever, right? How to get them to think about these things. And I think really that if any of them know someone who has sustained either a young death, unfortunately, or is inflicted with some type of early onset illness, that they do need the help of a parent or a friend to step in and help them. So it really is such a more enjoyable way of living through a very difficult situation oftentimes. So I don't see any other questions, but anyone is welcome. Do we have anything else verbally? Anyone have a question they'd like to ask? If not, I'll go back to my screen share and we can wrap this up. Conclusions and next steps. Contact your medical professional to have a MOLST or POLST put in place. I'm extremely emphatic about this. It's a great new form. Very, very good that they've come up with this, and it has so many nuances with it. But at your next PCP appointment, please remember to ask them to help you fill out a MOLST form or a POLST. I want you to communicate your healthcare wishes with your healthcare agents. And you see I have an S at the end of agents. And that means that if you have a spouse or a significant other and you've named them, then if you told them all of your, like, I want, to do this, I want you to do that, and they predecease you, then you're kind of in the same situation as if you never even had it or had the discussion. So I want you to talk about what are your healthcare wishes and discuss it with your healthcare agents. Contact our office if you or a loved one is well or is starting to experience memory loss and needs to have their legal documents that we've mentioned, have them put in place. And to help with the financial burden of that, you can look in your email next week for a thank you gift for attending today. And that will just kind of hopefully give you a leg up on and an incentive to start to get some of these things in place. Whoops. Sorry, I'm really not in control of my mouse today. So I think that that's pretty much it for today. I'll stop the share. And thank you all for joining me. And from a memory loss perspective, again, some of it is age appropriate. You should be in touch with your doctor if you're feeling yourself, if you're getting a little nervous about it. Ask your doctor at your next PC appointment to do a mini mental exam. It's a series of 20 questions, and that you can kind of get a score. I think if you're 22 and above, you're okay. But if you score a little low, it might be the signs that you're starting to experience some memory loss and that you do want to have some documents in place if you are starting to experience some memory loss. If that is the case, I just had a client a couple weeks ago that happened fairly quickly. She went to her doctor. The doctor set her up with a neurologist. She's having some more advanced testing done because she wants to be proactive. She doesn't want to put her head in the sand. She wants to know where she's at. That's one group of my clients. The other group is they want to keep their head in the sand and think that this is not happening. And if you want to do that, I'll support you with either way you want to go. But I do encourage you to do what you can to be proactive. Take advantage of the information and the data that's out there, because we are making tremendous medical advancements every day, every year, especially with the combination of medical advances and the computer era. We are seeing advances in medical care like equivalent to what the advances we made in the Industrial Revolution years ago. So do be positive and optimistic, even if you're starting to experience some memory loss, that there is so much help out there from medical professionals, as well as the supports that can be put in place. I do see I have a question. Joy, you can go ahead and ask your question. So we'll be having some additional webinars. I try to do one about every month or so. And we just do different topics. I often take a topic that is brought on by a client interaction, or if I get a lot of clients asking me the same situation or the same thing, I think it's noteworthy to try to speak about it in a general way. So Joy writes, if HIPAA is in place, but then I go to a doctor's office and submit a local form, which is different from the legal HIPAA, which one trumps? For example, if more people on the legal HIPAA, but less people on the local HIPAA. So on a HIPAA, it's a federal form, and they trump each other not by really location or whether it's local or federal, it's by the newest one. So you would need to make sure to update your HIPAA at each institution you have it at in order for it to be the most current HIPAA that will be in place. So if you want to remove someone, you would need to put a new one in place at the last one, or just remove it. And then your healthcare proxy always has the ability to get at your protected healthcare information. So if you don't have a HIPAA, your healthcare agent will have the right to have access to your protected healthcare information and to get information from the medical community. But then after that, no one else will have the ability. So if you're giving, say, a spouse or a significant other the authority under the HIPAA or under the healthcare proxy, even your successor healthcare agent will not have access in most cases. So you really do want a full HIPAA in place. Okay, well, I don't think I have any more questions, but if you do, you're more than welcome to email us. And thank you all so much for participating. It's great to see a lot of familiar faces as well as some new faces. And as always, Guthro Law is here to help you with all of your memory loss, legal documents, your financial documents. If you want to trust, if you want to do elder law planning and start to protect your assets in the event of a nursing home, we can do some proactive planning under the 5-year look back, as well as if you're in an emergency situation and you haven't done any planning and you have a large amount of assets, we can still do emergency planning to try to help you figure out how we can at least maybe save some of the assets from the grip of a nursing home. But we're here, and also probate upon someone's passing. We do a lot of probate work, but my goal as your estate planning attorney is to create an estate plan for you using a revocable trust or an irrevocable trust to avoid probate and let everything be handled in a very private way, in a very quick way, with a lot of detailed information about how you would like your assets to transfer upon your passing. Great to see you all. Thanks again.
If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.